On June 9th, Judge Louis Liman dismissed Justin Baldoni's defamation lawsuit against Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR, and The New York Times. His opinion and order stated, the motions to dismiss are granted and the court will not grant leave to amend the majority of the Wayfarer party's claims because the amendment would be futile. The dismissal of the claims does not rest on technical pleading defects. I want to make that very clear. The case was not dismissed on a technicality. It was not dismissed because of personal bias either. Because if that were true, to borrow a bit of legal jargon, the claims of corruption would include more than conclusory statements and would actually point out the defects in Liman's reasoning. And I haven't seen any of that. Regardless of personal opinion, it is a pretty major loss for Justin Baldoni, and anyone trying to spin it in a different direction is not a reliable source of information. Either they didn't read Judge Liman's opinion and order, or they didn't understand it. That's why I wanted to put out this video, to break down Judge Liman's opinion and order for those who would like a summary, need some guidance, or are just curious about how things turned out this way. Hi, my name is Petal, and I like to do close readings of various texts and media, from light novels to anime, and I guess even legal documents. I'm not a lawyer, I want to make that very clear, just a reader, and I only want to help clarify to others how Judge Liman justifies the dismissal of this case. This is mostly a summary according to my understanding of the document as presented. Any and all analysis is based on a close reading of the text. If I get anything wrong, feel free to bring it up in the comments. I'll correct myself in a pinned comment. Just be respectful because personal attacks will not be entertained. I also believe the judge was very fair and neutral, so I don't want to have a discussion about Judge Liman's personal life or speculate on his personal bias. He is a sitting federal judge with a great professional record from what I know. He deserves to be taken seriously. Brian Friedman has also made no declaration of a future attempt to appeal the judge's decision as of the recording of this video, which I think speaks to how well-reasoned this document is. In this video, I will be going over how he organized this 132-page order and his reasoning for dismissing each and every claim. Along the way, I'll provide commentary on things I found notable, but this is meant to be a summary, so I'm not going to discuss every detail. We can talk about it in the comments, though. The beginning is very standard. Liman identifies the parties involved in this litigation and acknowledges the Lively party's motions to dismiss, motions for award of attorney's fees, including Lively's additional motion for treble damages and punitive damages pursuant to California Civil Code 47.1, and the motion to strike Exhibit A, aka the timeline. After stating his decision on each motion, yes to the motions to dismiss, no to the motion to strike the timeline, and no to the motions for fees, though without prejudice to renewal, he then goes into the background of the case, stating that, for the purposes of this motion, the court accepts as true the well-pleaded allegations of the Wayfarer party's amended complaint. I should mention now that Liman uses the word allege in his opinion and order multiple times, but sometimes it refers to the things the Wayfarer parties said happened or to specific accusations they make against the defendants, and sometimes he is referring to the claims that he thought were well pleaded enough to be considered. So even if they say something happened, if they didn't provide enough factual evidence to support it, he may say they did not allege it. This is usually when he tries to explain the crucial elements they're missing that would otherwise show they have a plausible claim. It's an important distinction to keep in mind. Finally, he emphasizes that this narrative does not reflect the court's own findings, but simply repeats the account of events by the Wayfarer parties, meaning that he will trust the Wayfarer version of events as described in the amended complaint for the purposes of making this decision. But that doesn't mean he's decided it's all true, it's just standard protocol when it comes to the pleading stage. This is a point I made in one of my previous videos, but we need to approach the allegations made in each lawsuit as honest and being made in good faith, especially if a verdict has not come out yet. This is the standard of the law, and it is why a lot of my earlier videos and skepticism address Baldoni's admissions and contradictions in his own claim. But I'm getting ahead of myself. In addition to the Wayfarer party's amended complaint, he also lists the additional documents he will be taking into consideration as a matter of law, as they are integral to the complaint, and by quoting from it extensively, the entire document is deemed to be part of the complaint. Liman explains that the purpose of this rule is to prevent a complaint from surviving simply because a clever plaintiff included certain parts of a key document and left out others. This means some plaintiffs might take quotes from certain documents out of context and misrepresent the entirety of the document, so it is necessary to see them in full context. A footnote on page 5 mentions that Wayfair objected to the emails with the New York Times being included, even though these emails represent the implied contract they claim the New York Times breached. These documents Liman lists are the New York Times article, the accompanying video, Lively's CRD complaint, her list of 17 protections, and the emails between Wayfair and the New York Times. However, the court does not consider Exhibit A because it is significantly but not entirely repetitive of the amended complaint, and it does not set its claims in the numbered paragraphs as required by Federal Rule of Civil Procedure 10. The reason he does not strike Exhibit A, however, is because none of the defendants have identified any particular prejudice caused by Exhibit A, and motions to strike are generally disfavored and should be granted only when there is a strong reason for doing so. Personally, I thought this was very interesting, given what he struck from the court record just a week before. With all these caveats and explanations out of the way, he describes each party involved in the case and it ends with us, then summarizes the Wayfair's 224-page amended complaint in roughly 28 pages. For those who want a concise summary without Friedman's dramatic flair and intentionally misleading rhetoric, I recommend going over pages 6 to 34. As someone who has read both documents in full, I appreciate that there is a document on record that explains the Wayfair's parties' claims and allegations at their core. I noticed during the summary that Liman presents only factual allegations, and where the conclusions rely on heavy extrapolation, he does not present the Wayfair parties' interpretations of factual events. On page 14, he even clarifies the kissing by Lively, which Baldoni mentioned was unchoreographed and not improvised, reflects the fact that the scenes included kisses as written in the script. Though Liman does not directly contest the suggestions made by Baldoni when he included this in the amended complaint, I thought this was notable because it demonstrates that though Baldoni mentioned that Lively varied the number of kisses in a scene with each take to discredit her claim that he was improvising intimacy, he'd made a false equivalence because her kissing scenes were unchoreographed but still scripted, and she is accusing him of improvising intimacy. Liman also summarizes Lively's now infamous dragon text without interpreting it as a threat, as Baldoni claimed he had at the time. I've talked about how in context this does not make sense as a threat. After going over the procedural history, where it should be noted after 2.5 months since the first amended complaint and nearly a month after the final motion to dismiss from Lively was filed, the Wayfair parties filed a letter notifying the court that they would not move to amend their pleading by the April 18, 2025 deadline. Liman finally gets to the legal standard to survive a motion to dismiss. The first line is really important. To survive a motion to dismiss, the complaint must include sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. That means that the facts, as the Wayfair parties have presented them, have to be enough to show that the defendant is plausibly liable. Given that all their claims were dismissed, that means that the Wayfair parties have, taken at their word, not provided enough facts to make a case against any of the Lively parties. Liman next explains his duty in this case is to determine whether the claims are plausible, and that is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. He provides a general summary of his opinion and order on pages 37 to 38, but this is a close reading of the full order, so I'm going to skip ahead a little and go over a few house-cleaning notes before I get into how he assesses each of the Wayfair parties' claims. If you're not interested in discussion on choice of law and impermissible pleading, you can jump ahead. First, choice of law was a point of dispute during the motions to dismiss stage. The Wayfair parties pleaded their claims under California law, and Lively agreed, but Sloan, Reynolds, and the Times argued that New York law should apply to the claims against them. The key differences between California and New York law are that New York law does not recognize causes of action for civil extortion, false light invasion of privacy, or negligent interference with prospective economic advantage. The New York Constitution provides independent protections for statements of opinion, and the two states have different statutory privileges against defamation, namely California Civil Code 47.1, which privileges reports of sexual harassment and assault. In the case of Sloan and Reynolds, Liman says that the Wayfair parties are unclear in pleading where the facts underlying the claims against Sloan and Reynolds occurred to choose a jurisdiction. So he chooses to analyze the claims under California law for the purposes of this motion. However, he chooses New York law for the claims against the New York Times because in multi-state defamation cases, the traditional rule that the law of the plaintiff's domicile applies is only presumptive and may be overcome if some other state has a more significant relationship. And New York has strong policy interests in regulating the conduct of its citizens and its media. So usually the jurisdiction is chosen based on where the plaintiff lives, since defamation would have the greatest effect on them in their own community. But since the New York Times is a major news and publishing outlet, a decision on this case will have a greater impact on New York as a whole. Also, as a footnote, Liman points out that Sarowitz lives in Illinois, but no party has argued for the application of the law of Illinois. Since he's decided New York law shall apply to this claim against the New York Times, that means that the claim of false slight invasion of privacy against the New York Times does not need to be discussed, and he will need to assess if the independent protection for statements of opinion applies to the New York Times article and video. The lively parties also argued that the amended complaint engages in impermissible group pleading and otherwise violates Federal Rule of Civil Procedure 8, where a complaint is required to give the adverse party fair notice of the claim asserted so as to enable him to answer and prepare for trial. Basically, they said the amended complaint was so lengthy and confusing that it left defendants unable to discern which of them purportedly injured which plaintiff and how, leaving them unable to prepare properly for their defense. However, Liman says that it is not so confusing or lacking in substance that dismissal is appropriate, and he believes defendants have adequate notice of many core claims. There are actually various footnotes throughout the opinion and order in which he points out the weaknesses in certain arguments from the motions to dismiss submitted by the lively parties, demonstrating that he really considered every argument and response. This lends credibility to his opinion and order. He goes on to add, where the amended complaint does lack clarity, the court will consider only the claims of which defendants have fair notice and will not parse through the allegations and documents to determine whether a claim could theoretically be stated. This means he won't make the Wayfarer parties' case for them either, if anything was unclear. Further, the Wayfarer parties have an obligation to identify the statements which harmed them, rather than forcing the defendant to guess at which statements are actionable. So, let's look at how he organizes his arguments. First, he identifies the two key types of claims made. I think this was a wise decision, as these two claims are the main talking points of this case at this moment, and some of the other claims also hinge on whether or not these claims hold up in the first place. Ultimately, this leads to a more expedient delivery of his decisions on the remaining claims. The first claim is a claim of extortion in order to steal the film from Baldoni and Wayfarer. They claim Lively threatened to refuse to act or promote the film and attack Baldoni and Wayfarer in the press if she was not granted control over and credit for the film. The second claim is defamation and false light, which the lively parties allegedly committed by spreading a false narrative that Baldoni committed sexual misconduct towards Lively, then engaged in a smear campaign to ruin her reputation. The other claims are breach of contract, tortious interference with contract or prospective economic advantage, and promissory fraud. Here's how he structures the sections concerning the first two claims. After going into depth about the law and legal standards, he explains how the laws apply in terms of the allegations made by the Wayfarer parties, then draws his conclusion. He spends a great number of pages on just these two claims, but when he moves into the explanations for the dismissal of the remaining claims, these sections go by very quickly, much like his brief list. So we're going to spend a long time just talking about civil extortion and defamation. Let's get into it. Liman begins by outlining the allegations made in the Wayfarer party's complaint, listing the threats they claimed Lively made. I'll list them on screen because he actually looks into each threat and what she was asking for in return in order to analyze whether or not they amount to civil extortion. 1. She refused to return to production unless they agreed to her return to production demands. 2. She threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfarer parties agreed to co-fund a screening of her version of the film. 3. She would boycott the premiere unless Baldoni was excluded. 4. Lively and Reynolds would attack Wayfarer in the press if it did not take the blame for problems during filming. Additionally, in footnote 23 on page 48, he notes but does not include among these threats the allegation that, in several instances, they took actions desired by Lively because of her past threats or because of a general atmosphere of threats and fear. That's because these allegations fail to connect particular threats by Lively with particular demands. Basically, you can't sue someone for what you think they might threaten to do. The lively party's arguments against these claims are that the alleged acts are not wrongful and also that none of them received money or property from the Wayfarer parties. Wayfarer's response was that they are not required to allege a transfer of money or property and that the threats alleged are sufficient. Liman says Lively, Sloan, and Reynolds have the better of the argument. First, he notes that both parties demonstrate different understandings of the tort of civil extortion under California law. The Lively parties argue that civil extortion is a cause of action for monies obtained by duress, which is separate from the crime of extortion. That's why it requires proof of actual damages. The Wayfarer parties argue that civil extortion is a cause of action based on the criminal extortion statute and that it does not require money or property actually be obtained. The civil standard is actually higher than the criminal statute. Footnote 26 on page 56 explains the difference between the tort of civil extortion and a criminal offense. A crime is an offense against the public, and the tort is a private injury. In a criminal offense, someone like a public prosecutor would pursue charges. But with regards to a claim of civil extortion, the injured party, like the Wayfarer parties in this case, would be the ones to pursue it. Blackmail and extortion are, in almost all jurisdictions, crimes, not civil causes of action. Liman acknowledges there are a few examples of case law supporting the Wayfarer party's argument, which basically goes to show that this is a very complicated issue, so he must interpret the law by looking into its history in California and understand its intentions before applying it. I won't be going over all of the history because he spends about 10 pages on this, but I did find it a very fascinating read. First, he asserts the tort of duress is not descended from the criminal law, but rather from the contractual defense of duress. This allows a party to void a contract and receive restitution for any benefits it provided if it entered into the contract due to unlawful threats, which leaves them no reasonable alternative but to acquiesce. This means that the law was derived from conditions in which one partly justified canceling a contract because, due to some threat or other unlawful behavior, they were forced to give into demands that ultimately cost them some degree of loss. In California courts, this stemmed from recognition that it would be unjust to allow a party to retain a benefit that it received in circumstances that the common law recognized as duress. And the cause of action is one to reverse a transfer of value, not simply emotional damages or distress. That means that a claim is made to reclaim something of value, not just to compensate for emotional damages or distress. The lineage of the tort clarifies 2 points important to this case. First, if a threat would not support a contract claim for duress, it is not sufficient to support a tort claim for civil extortion. And second, the plaintiff must allege that they suffered damages or lost something of value as a result of defendant's threat. Liman cites various cases, but says he relies on a particular court decision, Furman, as the most relevant authority for this issue. I'll summarize that case due to its relevance. In this case, the plaintiff alleged that the defendants accused her of illegally receiving satellite broadcasts and threatened to sue her unless she paid them $275 to settle the claim. Furman described the relevant claim as essentially a cause of action for monies obtained by duress, a form of fraud. However, the claim was dismissed because she had not paid the demand. We'll see exactly how relevant this case is in a bit. The Wayfarer party cited one particular court decision in their defense that a monetary loss need not apply, Monex. But Liman points out that Monex directly conflicts with Furman, and in fact, no published California case has adopted the reasoning in Monex, and the decision has been largely disapproved by the federal courts for this reason. At least one published California decision has expressly stated that Monex does not reflect California law. So, how does he now apply this to the Wayfarer party's complaint? He tackles each of the 2 key points discussed earlier individually, going over each threat. However, alleged threat number 4, that Lively and Reynolds would attack Wayfarer in the press if it did not take the blame for problems during the filming, is not actionable because Wayfarer did not acquiesce. See? Furman. Before I get into his analysis of the other threats, let's review the stipulations required for this civil extortion claim to survive. First, the threat must support a contract claim for duress. Second, did the threat result in a loss of money? The short answer is no. The long answer is, of course, a bit more complicated, but we can start by looking at the contractual element. Liman says that Lively did not threaten to physically harm the Wayfarer parties or their property, nor did she threaten a false lawsuit. According to the Wayfarer party's account of things, she didn't actually threaten to do anything. She threatened to not do anything. And they don't allege she was under any obligation to do those things because they don't provide any facts to support the obligation. The issue then becomes a question of whether Lively's alleged threats violated a contractual agreement, and did they lead to Wayfarer losing any money. Hi, editing pedal here. I think this section of the original script was unclear, so let me explain. Usually, the contract claim for duress would require the defendant made a threat to the effect of, if you don't do X, I will do Y. But Lively's threat was, if you don't do X, I won't do Y. So, Wayfarer would have to prove that she was under some obligation to do Y in order for it to work as a threat. Okay, back to the summary. The Wayfarer parties do not allege facts to show that Lively had a contractual obligation to promote the film or to approve marketing materials, nor do they allege she had any obligation to attend the premiere with Baldoni. And while they plead that Lively had an obligation to act in the film, they do not allege that she had such an obligation no matter the circumstances. Her refusal to provide that which she has no obligation to provide is not a threat. It is a bargaining position. This phrasing is significant in the context of a workplace dispute. Aside from the fourth alleged threat, the other three can be summarized as Lively refusing to act or promote the film if the Wayfarer parties did not provide her with this and that. The this and that do matter, but so does the form of her threats. To put it simply, she was threatening to withhold labor in order to make demands, not unlike what had just occurred with the SAG and WGA strikes. This is important because the Wayfarer parties have characterized her actions as an attempt at a hostile takeover, but many in pro-Lively spaces have stayed focused on her initial CRD as a workers' rights issue. And Liman seems to understand that as well, at least in regards to threat number 1, the return to work demands. Even if the Wayfarer parties did include a contract to show that she refused to do that which her contract required her to do, that would not alone be sufficient to support a claim for civil extortion. That's because, under certain circumstances, a breach or threatened breach of contract may be reasonable. Liman provides a few examples. First, one party may break a contract and pay damages. Second, contract modifications and renegotiations are also not uncommon practice. This one, in particular, applies to Lively's insistence on the return to production demands. The Wayfarer parties allege the list of demands before returning to production was drafted for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in sexually inappropriate misconduct, but there are no allegations Lively ever made such a threat. This allegation by the Wayfarer parties is essentially conjecture, and Liman does not consider it a factual allegation of a threat. Liman points out it is not unusual for employees to seek changes or improvements in workplace conditions, and an employee can insist on protections at workplace for sexual harassment without being accused of extortion. In cases of contract renegotiation, Liman points out the importance of differentiating between a bad faith threat and an attempt to press a claim that is within a party's rights. Now, at what point does an employee's demands become unreasonable and can be cause for an actionable claim? That would be where economic duress is involved. However, courts consider a claim to involve economic duress only under limited circumstances, generally involving the wrongful exploitation of business exigencies to obtain disproportionate exchange of value. This would require two things: that the threat was made for some purpose unrelated to the contract, or that there was a disproportionate exchange of value. However, all of her demands on the 17-point list were related to the conditions of her work and largely involved adherence to protections for Lively and other cast members. The only apparent cost to the Wayfarer parties was hiring an additional producer, which would not financially benefit Lively. Thus, they do not allege a disproportionate exchange of value. Regarding the allegation that Lively threatened to not promote the film unless they allowed her to edit the movie, give her a producer credit, and support her in getting the PGA mark, Liman notes there is no allegation regarding Lively's obligations to the Wayfarer parties regarding promotion, and these demands do not involve a disproportionate exchange of value, as Lively insisted on taking on additional work for no additional pay. Liman also points out her demands were related to the contract and, during this section, draws attention to the logical fallacy behind the Wayfarer parties alleging that they did not believe Lively deserved the producer credit or the PGA mark, while they also allege that she took over significant production responsibilities. When he lays things out like this, I hope it's clear how ridiculous some of these claims are. As an additional complication to their overall claim, there are also contested points in the amended complaint. The Wayfarer parties are vague about who had the rights to what. First, it is not clear whether the Wayfarer parties, as opposed to Sony, had the ultimate right to choose the cut of the film. There are indications from the amended complaint that such rights resided with Sony. When she refused to promote the film, if they would not allow her editing power, filming was complete. So, if they had the right to put out a film with Baldoni's edits in the first place, they were not without the ability to do so. Wayfarer also did not allege that Lively's editing or the eventual release of her cut of the film caused them actual monetary loss, because they can't really show that it made less money due to her editing. There is no allegation that Baldoni's version of the film was of greater value than Lively's. For that independent reason, the Wayfarer party's civil extortion claim related to the demands for creative control fails. Also, the Wayfarer parties were not without remedies. If Lively refused to fulfill a contractual obligation by not performing or promoting the movie, they could have sued. But for what appeared to them to be good business reasons, they elected not to do so, and having made their decision, they cannot now seek to recover damages for what they would have obtained. Even if losing her for promotion cost them box office numbers, a loss of profits is not the same as duress, and they cannot claim recovery for hypothetical damages. I suspect it would also be difficult to prove such damages given the success of the film. The alleged threat to not attend the premiere if she had to do it with Baldoni also fails because, once again, they do not allege she had any such obligation, there is no threat extrinsic and unrelated to the production of the film, and the separation of Baldoni and Lively is not alleged to have had any financial implications. Finally, their feelings about the conditions at the premiere being demeaning and humiliating do not support a claim relevant to civil extortion, and their feelings about the PGA mark amount to a moral injury, not a monetary one. As for Sloan and Reynolds, the judge finds them not liable because the only instance in which Lively and Reynolds allegedly threatened to spread defamatory statements was in demanding that the Wayfarer parties make a harmful public statement, and the Wayfarer parties did not do that. And if Sloan and Reynolds actually spread defamatory statements, they would be liable in defamation, not civil extortion. Finally, allegations of a purported conspiracy to commit civil extortion are entirely conclusory. Thus, his conclusion on the first claim is that Lively's actions do not constitute civil extortion under California law, and can rather be considered legally permissible hard bargaining or renegotiation of working conditions. They also do not show that Lively's actions damaged them. Now we can finally move on to defamation. This claim was brought against all the defendants who are accused of having made statements that 1. The Wayfarer parties engaged in, permitted, and or failed to prevent sexual inappropriate conduct toward Lively, and 2. The Wayfarer parties retaliated against Lively and others for reporting the alleged sexual misconduct for the purpose of damaging her image and reputation. The Wayfarer parties allege a conspiracy to spread these defamatory narratives to the New York Times and other agencies, and that the Times committed defamation by publishing them. As with the civil extortion claim, Liman explains the legal standards first. However, he does not go as deep into the history of California or New York defamation law, and most of this section is definitions of defamation and special privileges protecting certain statements. Though the elements of defamation are similar in both New York and California, remember that New York provides independent protection for statements of opinion, so this will be assessed to see if it can be applied to the New York Times. First, Liman defines defamation as constituting an injury to reputation by a false oral or written communication. Under California law, the tort of defamation involves a publication that is false, defamatory, and unprivileged, and that has a natural tendency to injure or that causes special damage. Each publication ordinarily gives rise to a new cause of action for defamation. However, for mass communications, California has adopted the single publication rule. In this type of publication, the plaintiff is deemed to be harmed once, which is when the publication was first distributed. Statements of defamation must specifically refer to or be of and concerning the plaintiff, and must also contain a provable falsehood. So this applies only to statements of fact and not opinion. This is because opinions are protected by the First Amendment. However, the publication may be actionable if a reasonable trier of fact could conclude that the published statements imply a provably false factual assertion. That means it counts as defamation if someone who reads or hears the statement could reasonably infer the lie. To determine whether a statement is actionable fact or non-actionable opinion, courts apply a totality of the circumstances test, in which they consider both the language of the statement and the context in which it is made. The standard is based on the natural and probable effect upon the mind of the average reader. Truth is a complete defense to a defamation claim. California law permits the defense of substantial truth, which means that it's enough if the general gist of the statement is true, even if not every detail is accurate. Defamation also takes into account whether or not the plaintiff is a private or public figure. Where the plaintiff is a public figure, the plaintiff bears the burden of showing the falsity of the statements. This is because public figures have significantly greater access to the channels of effective communication and hence have a more realistic opportunity to counteract false statements. The state of mind of the defendant necessary to prove a defamation claim depends on whether the plaintiff is a private figure or a public figure. If the plaintiff is a private figure, the standard under California law is whether or not the defendant failed to use reasonable care to determine the truth of the statement. However, in Baldoni's case, if the plaintiff is a public figure, they may prevail in a libel action only if they prove that the defendant's defamatory statements were made with actual malice, i.e., actual knowledge of falsehood or reckless disregard for the truth. Liman makes a distinction between this and the common meaning of malice later on in his opinion and order, but I'll just go over it now. The legal standard of actual malice is higher than the colloquial understanding of malice. The actual malice standard is not satisfied merely through a showing of ill will, and failure to investigate does not itself establish bad faith. That means that as long as a defendant can be shown to have had no reason to doubt the information they were repeating, they would not be liable for defamation. In short, if you sincerely believed what you said at the time, that's not defamation. Since the New York Times is a print publication, the question of whether or not they committed libel is also considered. A claim for libel requires that the publication is libelous on its face or if special damages have been proven. However, libel per se could be claimed when a listener could understand the defamatory meaning without the necessity of knowing extrinsic explanatory matter or additional outside information. California recognizes a litigation privilege, a fair report privilege, and a privilege for statements by the victim regarding an incident of sexual assault, harassment, or discrimination. The last one is California Civil Code 47.1, which Lively invoked in her motion to dismiss, and the amicus briefs were filed on behalf of. The litigation privilege applies to all kinds of truth-seeking proceedings, including administrative, legislative, and other official proceedings. I've seen some people online questioning litigation privilege and using absurd examples to make their point. But Liman explains here the purpose of this privilege. The litigation privilege is an absolute privilege that applies to any communication made in judicial or quasi-judicial proceedings by litigants or other participants authorized by law to achieve the objects of litigation, and that have some connection or logical relation to the action. It aims to afford litigants and witnesses free access to the courts without fear of being harassed subsequently by derivative tort actions. Basically, without litigation privilege, anyone could be sued for trying to make a claim in court by the party they are filing against, and that would block the path to justice for those with valid claims. The fair and true report privilege applies to a fair and true report in or a communication to a public journal of a judicial, legislative, or other public official proceeding, or of anything said in the course thereof. The definition of fair and true here refers to the accuracy of the challenged statements with respect to what occurred in the judicial proceedings. The standard is the same as the standard for whether a statement is substantially true. This would apply to communications to and by the New York Times and basically requires that it reports a fairly accurate understanding of the information or contents from court-related proceedings. The privilege for a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination protects complaints of sexual harassment to an employer or court. This applies only to an individual that has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. That covers the legal standard. Now, let's move into the claims. Because of the multiple defendants and the claim of conspiracy, this section on application of law to dismiss this claim is broken down according to the defendant categories. Let's start with Lively, Sloan, and Reynolds. The Wayfarer parties accused Lively, Sloan, and Reynolds of conspiring to advance a fabricated narrative in the press that the Wayfarer parties had sexually harassed Lively, then embarked on a calculated and malicious smear campaign to destroy her reputation as retaliation for daring to complain about the harassment. They say that these three worked together to spread a false narrative to the Times, and that Sloan and Reynolds individually made false statements about Baldoni to other press outlets and Baldoni's agency. Liman takes a look at the statements first to determine if they are actionable. That is, are they considered fact or opinion, and are they protected under any particular privileges? Then he determines whether or not they were made with actual malice, that is, in the legal sense, not just general negative feelings towards Justin Baldoni or others. Finally, he makes his conclusion. The alleged defamatory statements are the statements made to the New York Times, the sexual assault and sexual predator statements, and additional statements made by Sloan. I'll be going in order, starting with the statements to the New York Times. Liman begins by identifying a fundamental obstacle to this claim, that being that the Wayfarer parties may not know anything of the Lively parties and the New York Times communication to each other. The amended complaint instead relies on inferences from the fact that the Times had the CRD complaint before it was publicly available and on conclusory and often dramatized allegations. His words, not mine. That the Lively parties worked together to feed the Times a false narrative. Since Wayfarer cannot plead direct facts, they must at a minimum plead circumstantial facts supporting a plausible inference that the defendant's behavior crossed the line from lawful to unlawful conduct. Though he does agree that it's likely the complaint was provided to the Times in advance, and it is highly likely that Lively, though not Reynolds and Sloan, played a responsible part, the act of providing the CRD complaint to the Times is not sufficient to constitute defamation because the complaint is protected by the fair report privilege. The Wayfarer party's response argued that the privilege does not apply because at the time Lively provided the CRD complaint to the Times, it had not yet been filed. But this is an argument that fails because under California law, a party need not wait until a legal document is formally filed before providing it to members of the press. Liman provides a bit of history, yet again, to explain that in 1996, the California legislature extended the privilege to protect individuals who communicate litigation statements to the press, which allowed such statements to be regarded as in the course of the proceeding. Thus, so long as litigation was actually contemplated seriously and in good faith, the fair report privilege applies to a party who communicates a complaint to the press before that complaint is publicly filed. Since Lively filed her CRD and a lawsuit following that in a timely manner, despite the Wayfarer party's assertions that she had no such intention, it is clear that litigation was contemplated seriously, in good faith. Liman also makes it a point to acknowledge that Lively's approach of filing the CRD first to seek a right to sue notice was proper. The fact that Lively chose to file in federal court rather than to continue in the administrative process does not deprive her of the benefit of the privilege. It is common that plaintiffs with more serious discrimination claims would prefer to bypass the administrative procedures to seek a vindication of their civil rights. Lively's actions support rather than detract from the inference that the administrative complaint was filed as a part of a genuine attempt to pursue Lively's claims. In a footnote on the same page, he adds, the amended complaint and facts of which the court can take notice show that Lively assiduously pursued her legal claims. Basically, Liman acknowledges that Lively is handling her own allegations against the Wayfarer parties in the appropriate way and appears to be pursuing legal action very seriously. Liman then goes on to acknowledge the Wayfarer party's argument that the fair report privilege does not protect litigating to the press and does not extend to communications which go beyond the allegations in a judicial proceeding. However, the Wayfarer parties do not allege that any text messages and emails not included in the CRD complaint and that could have been provided to the Times were defamatory. On the contrary, the messages discussed in the article but not in the CRD complaint are often supportive of Baldoni's narrative. His reasoning for this actually depends on the amended complaint's own narrative. If Lively provided additional messages to the New York Times, and if the New York Times should have known that the Wayfarer parties did not conduct a smear campaign from those messages, then that means Lively provided messages to the Times reflecting that a smear campaign was not waged, and that would not be defamatory to the Wayfarer parties. The Wayfarer party somehow also additionally allege that Lively provided the Times with text messages that were apparently selectively and deceptively edited. But Liman points out that litigants frequently will assert that the version of events recited by their adversary is selective and does not tell the whole story. And a litigant is not required to file a balanced pleading before an agency or in court. She is permitted to marshal the facts to tell her side of a contested story. As for Baldoni, he must respond in kind by telling his side of the story. Personally, I think it is pretty obvious that a plaintiff would not bring a lawsuit to someone just to add, but I could have misunderstood everything, and the Wayfarer parties should probably have known that. The Wayfarer parties insinuate that Lively, Reynolds, or the Sloan parties could have made other unspecified communications to the Times, but they offer no facts to support this other than what is already mentioned in her CRD complaint. Liman concludes that adding bare assertions of conspiracy is insufficient. He also includes a footnote on page 90 that points out the Wayfarer parties tried to argue that Lively told the Times that the Wayfarer parties' agreement to the 17-point letter was proof positive that sexual harassment was endemic on the film set. However, this does not properly allege that Lively made any such statement to the Times because the paragraph does not purport to report on particular actions or statements, but generally characterizes Lively's motivations for the return to production demands. It is, once again, speculation and conjecture on the Wayfarer party's part. With the statements provided to the New York Times out of the way, we can now discuss the sexual assault and sexual predator statements allegedly made by Sloan and Reynolds. Liman apparently did not consider the Vatuska statement provided recently, which asserted that Leslie Sloan never made such a comment and the Wayfarer parties misunderstood his text. This is because the question at the pleading stage is not whether there is a plausible alternative to the plaintiff's theory. The question is whether there are sufficient factual allegations to make the complaint's claim plausible. And the judge's opinion is that the Wayfarer party's interpretation of Vatuska's text in the amended complaint is plausible. He first acknowledges a false accusation of sexual assault or similar sexual misconduct can support a defamation claim because sexual assault is a crime and an allegation of criminal activity is defamatory per se. Thus, the alleged sexual assault statement from Sloan and statements from Reynolds that Baldoni is a sexual predator could reasonably be understood as a claim of fact. However, the Wayfarer parties have not alleged that Sloan or Reynolds had any knowledge that the statements they are alleged to have made were false or that they entertained serious doubts as to their truth. Remember, the legal definition of actual malice is not just disliking someone. After outlining what the plaintiff must plead, facts demonstrating the claim of actual malice is plausible with direct or circumstantial evidence, he discusses how he reached this conclusion with Sloan, then Reynolds. First, there is no allegation that Sloan was present when any contact between Lively and Baldoni occurred, nor are there allegations that she would have been told secondhand by Lively or Reynolds anything other than what Lively had alleged in the CRD complaint. Given the circumstances, and that Lively's version of events included that there was inappropriate and improvised kissing, as well as other details of that nature, and her CRD complaint referenced her earlier return to production demands, which lent credibility to claims of sexual harassment, Sloan would have had no reason to doubt her, and also could have reasonably and not recklessly concluded that Baldoni had engaged in sexual assault. I think this is honestly a pretty big deal for what will come with Lively's case if the judge is acknowledging this here. Though the Wayfarer parties argue that, as a close associate of Lively, Sloan had a motive to defame Baldoni, Liman points out that no allegations suggest any particular benefit Sloan would have derived from telling a falsehood in this context. He also schools everyone on what the legal definition of actual malice is again, but I trust you all remember. The allegations that Sloan was part of a conspiracy to spread knowing falsehoods is deemed entirely conclusory because there are no factual allegations to support that Lively told Sloan she was not sexually harassed or that Lively and Sloan agreed that Sloan would spread rumors of sexual assaults despite knowing they were false. Similarly with Sloan, Reynolds was not present for any events during filming, and the amended complaint does not provide any reason he would have doubted Lively's version of events. In fact, Liman goes further to state that, in fact, several allegations in the complaint support that Reynolds believed that Baldoni engaged in sexual misconduct towards Lively. First, Reynolds screamed at Baldoni after finding out that Baldoni had asked his trainer about Lively's weight. Then, Reynolds yelled at Baldoni and demanded that he apologize for actions in connection with the return to production demands, becoming further enraged when Baldoni refused to apologize. Given that the return to production demands concerned Baldoni's alleged inappropriate behavior towards Lively, the obvious inference is that Reynolds was yelling about this alleged behavior. The Wayfarer parties argue that actual malice can be inferred from Reynolds' deep disdain for Baldoni, but Liman believes the facts alleged in the amended complaint in fact suggest an inference that Reynolds disliked Baldoni because he believed he did engage in misconduct towards Reynolds' wife. In a footnote on page 97, he also points out that Baldoni may have denied this behavior, but this isn't enough to trigger doubt because mere denials are so commonplace in the world of polemical charge and countercharge that, in themselves, they hardly alert the listener to the likelihood of error. Meaning, of course he would deny it, anyone would, but why should Reynolds believe Baldoni over his own wife? Many of us in pro-Lively spaces have mentioned before that Baldoni's own complaint kind of reveals more than he perhaps intended it to. It's always felt ridiculous to see him cry about how Reynolds was mean to him, given that it only made sense for him to be mean to the guy he believed sexually harassed his wife. In conclusion, the Wayfarer party's theory of the case is that the Lively parties conspired to exaggerate and fabricate events that occurred on set, but it does not hold water because the court cannot simply infer on the theory that Lively knew her allegations were false that Reynolds and Sloan also would have known them to be false. Lively's version of events is not so inherently improbable that there was obvious reason to doubt it. A footnote at the bottom of this page points out, Lively's version of events involves only mostly small, if crucial, departures from the account given in Baldoni's amended complaint. Even if Lively only slightly misrepresented, exaggerated, or failed to review particular details, Reynolds and Sloan could easily have believed she was sexually assaulted and that Baldoni engaged in sexual misconduct. Thinking about this as a critical reader, if the only difference between their stories boils down to misinterpretation, exaggeration, or particular details when taking Baldoni's story as factual and honest, it should be pretty easy to see things the other way around when considering Lively's claims. Isn't Baldoni's defense really just an effort to reinterpret and downplay Lively's allegations? Now, Liman discusses the additional statements made by Sloan concerning Lively's accumulation of power over the production and resulting turmoil. Unlike with the sexual assault and sexual predator statements, Liman determines that these statements cannot reasonably be interpreted as stating actual facts. They are better classified as rhetorical hyperbole, and in fact convey nothing negative about the Wayfarer parties. Though the Wayfarer parties argue that the statements imply undisclosed facts, Liman does not believe a reasonable reader would interpret Sloan's statements to mean that Baldoni had engaged in misconduct or had otherwise, through his own actions, caused the cast to turn against him. He goes on to list a number of other reasons that a person may be disliked or even hated. A director may be hated by the cast because he is demanding, obstinate, incompetent, or simply annoying. It may be for no particular reason or no single reason alone. It may be for reasons having nothing to do with his skills as a director. I think Liman's additional statement that it may reflect poorly on the cast and not on the director is proven by the general internet's response to Blake Lively, Jenny Slate, Isabella Ferrer, and Brendan Sklenar. The Wayfarer parties also tried to argue that Lively was responsible for the statements made by Sloan and Reynolds because, as her publicist and husband, they acted as her agents. The legal terms they used to argue this were respondeat superior and independently under principles of agency. The first is a form of vicarious liability to which, by default, an employer may be held vicariously liable for torts committed by an employee. However, since Liman already established that Sloan did not commit a tort, she has done no wrong for which Lively can be held vicariously liable. Under principles of agency, an employer may be directly liable for acts of its agents. This actually doesn't require Sloan or Reynolds to have known the statements are false, only for Lively to have lied. It also requires that Lively was responsible for them making them. However, the essential elements necessary to establish an agency relationship are manifestation of consent by one person to another that the other shall act on his or her behalf and subject to his or her control, and consent by the other so to act. Yeah, I know, that sentence was a lot. It just means that Sloan and Reynolds agreed to act on Lively's behalf according to orders given by Lively. But this agency cannot be implied from the marriage relationship alone, and Reynolds did not need orders from Lively to talk to WME on her behalf. He also was a client of the agency and capable of communicating with the agency on his own behalf. As for Sloan's statements, they were informal and off-the-record text messages, not press releases or official statements from Lively. The fact that Sloan is Lively's publicist is not sufficient to support that Lively controls Sloan's word choice in each text message, even when speaking on her behalf. Relatedly, the Wayfarer parties allege that each of the Lively parties conspired with the others to commit defamation. Under California law, conspiracy to commit tort is not actionable in the absence of an underlying tort. In conclusion, Lively is not responsible for any statements other than her CRD complaint, which is privileged. Reynolds and Sloan would also have had no reason to doubt her based on the information available to them, and the Lively parties cannot be liable for a conspiracy that was not carried out. Finally, we get to the defamation claims against the New York Times. Personally, I think this was some of the most interesting writing in the entire document. I was riveted. As a reminder from the section on choice of law, Liman chose New York law, so the claim of false light invasion of privacy is unactionable, and he has to consider if the independent protection for statements of opinion in New York is applicable. First, the Wayfarer parties claim that the Times committed defamation by publishing the article and the video, which stated that the Wayfarers engaged in, permitted, and or failed to prevent sexual misconduct and orchestrated a smear campaign against Lively. The Times argue that the article and the video are privileged as a fair report of Lively CRD complaint, and that the statement the Wayfarer parties engaged in a smear campaign is a protected opinion, and that the Wayfarer parties have not pled actual malice. I thought this was very interesting because Liman does think the article and video regarding the alleged sexual assault are subject to the fair report privilege, but that the remarks in the article and video about the smear campaign are not. Though we know both claims will fail, that is due to the Wayfarer parties having not alleged that these statements were made with actual malice. His writing reveals how important the standard of actual malice is in making a decision on a defamation claim, but his conclusion is also very revealing of how significant those text messages provided to the Times may be to Lively's claims for retaliation. So, let's get into it. First, New York Civil Rights Law 74 creates a privilege for the publication of a fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding. For the privilege to apply, an ordinary reader must be able to determine from the publication itself that the publication is reporting on a judicial proceeding and the report must be fair and true. However, the journalist may not go beyond the allegations and suggest conduct that is different or more serious than that alleged. You can see where this is going, right? The Wayfarers allege two types of defamatory statements. First, that certain of the Wayfarer parties engaged in sexual misconduct toward Lively, and second, that the Wayfarer parties orchestrated a retaliatory smear campaign to damage Lively's reputation after she reported their misconduct. The first statement is covered under the fair report privilege because it is clearly marked as complaints in Lively's legal filing and are privileged as a fair and true report of that filing. However, the article prominently states that the Times have reviewed thousands of pages of text messages and emails, of which only excerpts are included in Lively's filings. The article attributes several statements regarding the smear campaign to the text messages or the documents rather than Lively's complaint. It also contains messages not in Lively's CRD complaint. The video, like the article, includes some messages not included in the amended complaint. That means that the statements regarding the smear campaign report on more than what is included in the court proceedings and thus is not protected by the fair report privilege. So, Liman must now decide whether the statements considered in the context of the entire publication are reasonably susceptible of a defamatory connotation. He does his own close reading of the article and video, probably why this is my favorite part of the opinion and order, as it builds a layer of suspense while he goes through crucial lines and considers how to interpret the article's intentions and implications, as well as what caveats a reporter might or might not need to enjoy the benefit of the privilege, and concludes that a reader could reasonably understand the article to make the factual statement based on facts to which the reader does not have access via the CRD complaint that the Wayfarer party spread negative stories about Lively. The statement of fact criteria for meeting a defamation claim is met. The Wayfarer parties almost have a claim, except they once again fail to prove actual malice. The Wayfarer parties argue that actual malice is satisfied because the Times reporters reviewed private internal communications directly refuting the article. However, the Times claim the opposite, that the text messages contained in the article and the CRD complaint show that the Wayfarer parties did in fact engage in a smear campaign. Liman centers the issue on whether documentary evidence of undisputed authenticity would plausibly indicate that the Times made the statement with a high degree of awareness that they were probably false. Even drawing all reasonable inferences in favor of the Wayfarer parties, the evidence does not support that the Times would have held such doubts. This is where I think Liman's opinion and order gives some indication for what's to come for Wayfarer beyond this case. Liman states, the CRD complaint and article contain numerous messages and documents strongly suggesting the Wayfarer parties did spread negative stories about Lively. He cites the messages we should all be so familiar with by now, if some of us weren't distracted by a missing emoji. Here are some on the screen. Liman points out specifically that the Wayfarer party statements regarding sending negative content to Digital and Wallace's attempts to shine a spotlight on Blake and Ryan are inexplicable unless the Wayfarer parties were spreading negative content about Lively. It is fair to presume that the Wayfarer parties did what they said that they planned to do, and a reader of those messages would have little doubt that the Wayfarer parties engaged in a smear campaign. Though the Wayfarer parties claim certain texts the Times did not include absolve them of any culpability in a smear campaign, and they were not the only sources of the negative backlash Lively received, Liman states the Times did not say that Wayfarer were the only source of criticism to Lively. And furthermore, these texts do not explain how a specific reference to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan would be anything other than a reference to negative publicity about Lively. His most favorable interpretation of this for the Wayfarer parties is that the messages reflect the Times chose among a number of possible rational interpretations of a document that bristled with ambiguities, which is not enough to create a jury issue of malice. The Times also has no motive to favor Lively's version of events. It even includes additional context favoring Baldoni. It acknowledges criticism of Lively's promotional efforts. It prominently includes the Wayfarer party's denials. It states that Baldoni was unsure about the publicity tactics. These facts further cut against an inference of actual malice. Thus, the Times is not liable for defamation. That's it for defamation, and I promise we are almost done. Liman goes through his decisions on the remaining claims much more quickly, and I will have less to comment on as well. False light is dismissed with regards to Sloan and Reynolds because it is duplicative of the defamation claim. Since the defamation claim failed, so does the false light claim. This decision includes one of the more terse lines from Liman in which he says, the Wayfarer parties cannot benefit by the expedient of simply relabeling their defamation claim as false light. As mentioned earlier, this claim does not apply to the New York Times because false light is not actionable in New York. Liman goes over California law regarding the claim of breach of implied covenant in good faith first. It is stated that neither party in a contractual relationship will do anything which will injure the right of the other to receive benefits of the agreement. Wayfarer claims Lively violated that understanding by depriving them of their opportunity to produce, edit, and market the film. However, this claim fails because the Wayfarers don't meet the standard of alleging the existence of some specific contractual obligation or interference with the plaintiff's performance of the contract or the failure to cooperate with the plaintiff. Basically, they didn't provide the contract that Lively allegedly breached to point out what obligation she failed to meet, and they don't even allege any particular contractual provision that gave any particular Wayfarer party the opportunity to produce, edit, and market the film, or that prohibited Lively from involvement in the production, editing, or marketing of the film. They, in fact, also indicate several times that Lively did not sign her employment contract for the film. As for the claim that Lively and Reynolds intentionally interfered with a contract between the Wayfarer parties and WME, California law has 5 requirements for making such a claim. Instead of using generic terms like Party A or Party B, I'll just apply this directly to the parties involved in this case. 1. There must be a contractual relationship between Wayfarer and WME. 2. Lively and Reynolds had knowledge of the contract. 3. Lively and Reynolds carried out intentional acts designed to induce a breach or disruption of the contractual relationship. 4. There must be an actual breach or disruption of the contractual relationship. 5. There must be resulting damages. The tortious interference with prospective economic advantage also requires that the defendant engaged in an act that is wrongful apart from the interference itself. However, the Wayfarer parties do not allege that they had a contract with WME that Reynolds would have known about and then induced WME to breach, nor do they allege that he received any economic benefit from said breaching. They also fail to allege that WME was influenced by Reynolds' statement in any way. Since Reynolds' statements were already established earlier to not be defamatory, they do not allege that those statements were independently wrongful either. To meet the legal standard for a claim of promissory fraud, the plaintiff must plead the existence of a contract, performance by the plaintiff or excuse for non-performance, breach by the defendant, and damages. The promissory fraud claim made against the New York Times fails because the emails do not constitute a contract, since the New York Times does not offer to hold publication in exchange for anything. Liman goes on to say that even if it could be considered a contract, it was satisfied. The Times email said that if a comment was provided before noon, it would be considered. Comment was provided, and the Times considered it, including it in the article. There was no breach. The claim itself is also flawed because the Times did not promise to withhold publication after receiving comments, and the Wayfarer parties do not allege any further response they could have or actually would have made between 10:11 a.m. and noon had the article not been published. I I don't know how this wasn't just obvious from the start to some people. The logic behind this claim is absurd. While Liman acknowledges that when a motion to dismiss is granted, the usual practice is to grant leave to amend the complaint, it is well established that leave to amend a complaint need not be granted when the amendment would be futile. This is his reasoning for not giving leave to amend 7 of the 9 complaints. This part was really interesting because aside from saying that the dismissal of the claims does not rest on technical pleading defects, he also points out that the further evidence available to the Wayfarer parties now in their Exhibit A would actually cut against a finding of extortion. It shows that Sony and Wayfarer in fact resisted Lively's requests, and it claims Lively did not sign her acting agreement, implying she may not have had a contractual obligation towards Wayfarer to promote the film. He thus concludes that the promise that more unspecified facts will now change the central aspects of their core claims suggests a dilatory motive to extend the litigation rather than a legitimate belief that the amendment will alter the court's determination. This is one of his more pointed statements, as it implies Wayfarer would be using the further amendment as a delay tactic, and he simply won't allow that. For those keeping up with how the discovery process is going, I'm sure you know what I'm talking about. Still being quite generous, however, he allows leave to amend the 2 claims for breach of implied covenant and tortious interference with contract, because he cannot decide without seeing the contracts between Wayfarer and WME and Lively respectively. Personally, I'm not sure they are willing to provide those, as it would have made sense to have included them when making claims about a breach in contract in the first place. As for why he did not grant the motions for award of attorney's fees, etc., he explains that the law applicable to the claims against Reynolds and Sloan cannot be determined absent further factual development, and he has not ruled on whether Lively's statements were privileged under California Civil Code 47.1. A footnote from page 90 mentions that because the CRD complaint was privileged, Liman need not consider whether they fall under the sexual harassment privilege or were made with actual malice. He also did not take into consideration the amicus briefs filed in support of 47.1. I've seen some people try to spin this opinion and order as a loss for both Baldoni and Lively, and I don't think that's true, because Liman still tells the Lively parties that he will allow them to return with a case on which laws to consider regarding awarding fees. I personally think Lively has got a pretty good argument for the fee shifting provision attached to California Civil Code 47.1, because Baldoni's complaint really is the prototypical lawsuit targeted by the proponents of AB 933. He claims defamation regarding her comments about sexual harassment, and there are signs that Liman may not consider her allegations completely baseless. Overall, I think this opinion and order echoed many of the talking points already occurring in pro-Lively spaces. We've been discussing how the timeline actually works against Baldoni, that they never had a case for promissory fraud with the New York Times, that the Wayfarer parties seem to be delaying the case, that there are messages in the CRD that can't be explained away by a sarcasm emoji. And much like Liman, many of us have been looking at the situation from the point of view of an employee asking for improvements to their workplace, not a late-night drama featuring this season's hated woman. So, for those of you who are pro-Baldoni and wondering how things turned out this way, I really recommend reading this opinion and order with an open mind, without bias against Justin Baldoni or Blake Lively. Again, if you disagree with Liman's opinion and order, it should be because his reasoning was not sound, not because you have a theory he's somehow connected to Lively or Reynolds that you wouldn't be able to take as a claim to court yourself. As for today's question to chew on, why do you think Friedman didn't bother to file a motion to dismiss like the Lively parties did, especially if Lively's claims are so baseless? Leave any answers, questions, corrections in the comments. I'd love to keep discussing the case and especially this document. Part of the reason it took so long to finalize a script was because I kept finding more I wanted to talk about. The other part is that I can't put out videos of this length regularly while working my full-time job. And of course, I'm also sick, so sorry. That's why my voice is like this. Hopefully I won't have to do anything like this again anytime soon. Bye-bye for now.